As part of its ongoing role in support of the judicial network in Central and Eastern Europe, the Seeley Institute presents a series of seminars on remote judging, where we discuss and suggest best practices to guide judges as they come to grips with e-justice, fair trial rights, and international standards.
Hi everybody, I hope you're all well. It's lovely to see you again. Welcome back. Thank you ever so much for your really interesting and insightful discussions on the forum in these last few weeks. And I sent a summary to our two presenters who I'm going to introduce shortly. Just as before, we've got the first hour where we have a panel of two speakers. They'll make some presentations. If you have any questions for them, then please either put them in the chat function and I'll gather them together, or the speakers, if they're able to or willing to, can pick them up as they're going through. We're delighted to have two eminent speakers with us. I'm just going to make brief introductions and then I will hand over to them. So we have Judge Keith Raynor, who is a barrister. He's a fee-paid Crown Court judge, recorder in the Midland Circuit. He's got extensive experience as an advocate in criminal law cases on a wide range of issues. He's served as vice president to the Kosovo Specialist Chambers and was a senior prosecutor with the UK-Iraq Historic Allegations Prosecution Team. He's a leader in judicial integrity and has been a strong voice and advocate for judges during the COVID pandemic. Our second speaker will be Domagoj Frentic. Please forgive me, Domagoj, if I've not pronounced that correctly. Please do correct me. He is a judge in the Croatian Civil and Labour Courts and has been since 1999. He served as deputy chair and later as chair of the Labour Court in Zagreb, and is a disciplinary judge at the Department of Public Administration and Croatian Chamber of Architects. He's published widely on a range of judicial issues and participated in a number of international legal and judicial projects. So they are extremely well placed to make these presentations to you on remote hearings. So I'm going to hand over to Judge Raynor first for your presentation. Thank you.
Thank you very much, Rachel. I want you all to imagine, please, that you are either judges or advocates in a remote hearing. And this is what might happen. Good evening, everybody. I am Judge Raynor. I am in a courtroom in England. Because of the situation with the coronavirus pandemic, I am wearing a mask. I have instructed all the advocates who are appearing in front of me to wear a mask, or invited them to wear a mask. That is in order to protect each other in the coronavirus situation. This is a remote hearing with the judge and all participants appearing remotely. Having considered all hearing options available to me under my law, I authorize this remote hearing as being in the interests of justice. In my court, I'm assisted by two court staff. The two advocates, one for the prosecution and one for the defense, are now appearing remotely from their homes in other parts of England. Our connection in terms of the IT was checked 15 minutes ago. I can see all the faces of the advocates on the screen, and I have checked that they are all dressed appropriately for a court hearing. I make the following case management ground rules. 1, if you are not speaking, you must have your microphones on mute. I'm going to take the mask off just for ease, but you get the idea. 2, if you wish to raise an issue, please raise your hand physically or use the raise hand icon at the bottom of your screen, but do not put your microphone on until I say you can. Next, you may also use the direct message facility at the bottom of the screen to send a message. I make it plain that if any participant frustrates these proceedings, whether an accused or an advocate, I will mute the person concerned, and I may proceed in the absence of a defendant. In this case that we're doing, the defendant is in a prison, and there is a video facility in the prison, and the defendant is in that room and has connected remotely to these proceedings. The charge will be read over to him. He will plead guilty or not guilty, and I will then give further directions and orders for case management. So everybody pause there. That's a practical example. I want to say this. Most of the trial hearings that I do and have been doing today in my courtroom, they are hearings where I'm allowed by our law to do the hearing. So I hope all of you have a law in your countries that allows remote hearings. In England, there are plain instructions on what hearings can be done remotely and what hearings cannot be done remotely. So to give you an example, nearly all hearings before a trial are done remotely. Trials are not currently generally done remotely. In other words, let me explain. I have been in a trial for the last 6 days on allegations of historic sexual abuse. The advocates have had to come to court. Why? Because in England, we have 12 members of the public who decide if somebody is guilty or not guilty. They are called the jury. They are in the courtroom. I am in the courtroom. The advocates are in the courtroom. The defendant is in the courtroom. And we have to run the trial as a normal trial because the jury, as they're called, need to be able to see the witnesses and see the defendant. They need to be able to see how a witness gives evidence, their facial reactions, their responses, their demeanor, and their body language. And the right to fair trial might be impacted if you try to do a hearing, but most of you are in jurisdictions where you don't have a jury. Just very quickly, I've got 2 minutes left. Sentencing hearings. I have done sentencing hearings where I am sending somebody to prison, both physically with me in the courtroom and the accused in the courtroom. But I've also done hearings where I have been at my home address, in my house, in a room in my house, linked directly to the court. The defendant has been in prison, linking remotely again to the court. And I've even passed sentences as high as 18 years imprisonment from my home because of the need to keep the system going in the corona crisis. We are under enormous pressure in England and Wales. We have a lot of trials where we have 4, 5, 6, 8, 10 accused people, and trying to manage a trial in COVID conditions with 10 accused is very challenging. That is my 10 minutes up. Can I say, Frida and Rachel, there were some excellent questions put forward, and I'm happy to deal with questions later. That is my 10 minutes up.
Thank you so much, Judge Raynor. I think that was a fantastic start and lots of food for thought. I'm going to pass swiftly over to Judge Domagoj next, and then we'll have chance for questions. Thank you.
All right, thank you. So actually, I do have a question for Judge Raynor, but I will save it then for later. not to interrupt our timing and our schedule. So again, hello to everyone from Zagreb, Croatia. First of all, I would like to thank to Frida and Celie and Professor Murray for preparation of this course and for all the participants. It is very interesting and talks about the topic which is quite now relevant. And I will share with you some of my thoughts that are connected with the situations with the remote hearings and trials here in Croatia, but also in other countries in Central and Eastern Europe, because I think we share the similar legal systems and similar history, especially us from former Yugoslavia, aren't we? So um, it was very interesting to hear Judge Raynor coming from the country with a great legal history, such as England and Judiciary of England and Wales. Also, it was very interesting to hear in previous episodes the professors and judges from Poland, say Professor Swierzyński and Judge Golaczynski, and they had great insight on the Council of Europe provisions about the remote hearings. I will try to tell you a little bit how it works in a field in my country, and I would say in similar legal systems around my country. So I would say that first of all, and that is my later questions for Judge Raynor, we do not have in all of our countries, at least not in mine, we do not have the statute itself that talks about the remote hearing. So now, right now, it's basically the goodwill of the participants. Something we do have in a criminal part of judiciary, and I would say that it works best in that part because usually those are big hearings. You know, I will tell you a little something about our tradition in Eastern Europe, how we work, especially in the civil cases. We do not have like 3 days allocated for one case or something. Usually working day of judge, especially in a civil or say labor or economic disputes, are that you have many hearings throughout the day with different participants. And I will try to talk a little bit how to then use the modern technologies in view of such a workload when you have, say, 7 or 8 hearings a day with different participants and not one long trial with 4 or 5 accused in which is usually in criminal cases. So in criminal cases, we do have situations where we have remote judging, usually to hear witnesses from the other locations. And that was even before the pandemic. And it worked well, but with caveat that it took a lot of time and expertise, and it was pricey because that witness who is in another town, another city, was first located, then transferred to the local court, and then the whole setting was prepared for that witness. And later, and then it was connected to your courtroom where you preside and where you have the lawyers and all the other participants. Sometimes we had also the connection with the people who are sick or immobile, and they're sitting in their home, and the whole equipment is placed in their homes so they can be witness from the safety of their home. And it was connected usually to the criminal proceedings. So in criminal proceedings in Croatia, we do have that possibility. Unfortunately, and it's worked on currently, but unfortunately right now we do not have that possibility in a civil procedure. So as far as I know, and I know something that there is a draft of a new statute that will deal with that in more detail. And all the participants, including the lawyers, will be also electronically connected. So there will be possibility for the trials from the distant trials. The problems I can see is, and I already mentioned one, is the fact that usually the civil or labor judge or judge in economic cases, they do have a lot of they have a big workload, right? A lot of cases daily. So the whole system must be ready to load and unload for the every new case, because usually you do have each case every 30 minutes, every 25 minutes or so. And right now people are leaving and entering your courtroom, right? And if somebody is missing the mark or is late 5 minutes, then maybe he's late and you wait for that person and that sort of thing. So that will be a challenge, I think, for the technical staff and also for the judges and the clerks, how to do it many times over during one day. That's one of the challenges I think we are facing. Also, and it was also mentioned before, especially in presentations of our Polish colleagues, we do have a question of authentication, which will be also complex one, especially when we talk about the witnesses. Sometimes we do have witnesses in civil and labor cases, and it's still to be resolved. They will come to, shall they come to court, or they will, how can they give their testimony from home? That is, I think, unusual for our Central European point of view, and how to deal with that technically. So now we expect that witnesses will be still in position to come to court, and then the courtroom will be the place zero where everything is taking place, and then is transmitted to the other participants' lawyers, I think. So the other thing, which I think is a worth of examining, is question of discipline and proper attire, right? We do not have wigs and all in Central Europe. Sometimes even, unfortunately, we do not have even robes, but we usually preside in a civil clothes, right? So that will be a challenge to maintain discipline throughout the proceedings, which is online. And the other thing with the lawyers, I think in Central Europe, is that the tradition is that they often do have a tiny little offices. And it works well for now because usually they go out to the court, right? Now, if they have online, they're stuck in their small office. And if there are 4 of them in all days, in all normal, usually 3 of them will be out on a court and only 1 in an office. Now there'll be all 4 of them packed in an office with the computers on and with online trial. So we have a situation where the bar is signaling that, saying that the tradition of that unlucky tradition, the lawyers' offices are not necessarily big and grandiose, could be a problem, technical problem for the lawyers to participate, because if they feel uneasy about it, they will invoke the violation of Article 6 for certain of European Convention, because it's not easy for them. Sometimes they like to come to court, and the courtrooms, however humble in Central Europe, are usually suited for the proper trial. Now when their offices are becoming sort of spare courtrooms, it's opening some of the questions. And I think my opinion is that we are talking about all those range of issues in a context of modern technology and modern times, but also, of course, in the context of the current pandemic. And maybe it's not completely connected with our topic, but I would like to mention, first of all, the Honorable Judge Raynor mentioned that he has 1 or 2 administrative staff or clerks at homes working. So in my country, it's a big trade union issue, the public servants working from home, and how they're paid and who's paying for heating during the winter hours, because, and for the electricity or stuff like that, that's one thing, and same goes probably for the judges. So legal status of the homework is still unresolved, not completely resolved in Central Europe. And the other thing connected is, and I think that there are also a couple of international documents which are talking about that, and that is that it's more connected to the pandemic conditions. But before complete online trials, we are becoming with the participants in our chambers sort of frontline workers also, not completely like doctors, but almost like that. So that is also, I think that International Commission of Judges is talking about that, meaning that we maybe are in a position to require some special conditions and pay to be confronted with the participants. And I think that problem helps the development of the online platforms for the online judging, because it will resolve the problem of the pandemic in our courtroom, which we are now facing, because unlike Judge Raynor, I still do have live people in my courtroom, which is not very big, and daily we try to manage it. And I think before, in earlier parts of the course, they were mentioned that some strictly technical cases, non-payments and stuff like that, dealt on, people are dealing with that online. But I do have live people in my courtroom daily, and I hope that initiatives like that and daily changes we are facing will resolve that. So I think I crossed my 10 minutes long time ago. So that's for now. Thank you very much.
Thank you very much, Domagoj, for sharing those experiences with us. You mentioned you had a question for Judge Raynor. Do you want to ask that question now?
Right. So Judge mentioned that as a punishment for unruly participants, he will mute them. My question is, and that muting them is the same thing as putting them in all days in jail because they are unruly in a courtroom. My question is that judge's interpretation of current statute, or do you have the specific guideline, a new statute which says muting equals 1 day in prison for unruly performance in a courtroom?
Thank you. I'm going to pass back to Judge Raynor. You'd also mentioned that you'd picked up on some questions that in relation to the summaries of the discussion board. And so maybe if you'd like to respond to that particular question and then any other additional comments that you have. There's also one question from Manola in the chat function that has been asked about the difference between the two kinds of sentences, trials, in terms of fair trial issues. And then we'll come back to Domagoj if you have additional comments that you'd like to make. But I'll hand back over to you, Judge Raynor, for any additional comments or responses to questions. Thank you.
Domagoj, there is no law that deals with disruption to an online hearing. It's more the general existing law of a judge being able to control the courtroom and to take steps with a disruptive person. So no change in the law and applying the existing law. Second question, Manolo, I hope I've got the sense of it. The fair trial aspects apply, I think, both to a trial with witnesses really should be in the courtroom. But can I also add that we have occasionally allowed a witness to give evidence from home, but only if they put their passport up to the screen to verify their identity, and sometimes even a police officer present in the room where they are giving evidence to ensure that there is no pressure being placed on the witness. But the general rule, witness come to the courtroom. particularly for a trial where the members of the public, the jury, need to see the witness. But there also is, I think, an Article 6 point for the sentencing hearings. Because of the virus, I was forced to sentence 2 defendants from my home, but I did not feel particularly comfortable about it, because I believe that an accused, particularly if I am sending that person to prison, needs to be able to eyeball me in person, and I need to be able to explain my sentence in person. Now, the IT is pretty good, to be honest. We do have problems every day, but overall it's pretty good. So some could argue it's fine having sentencing online, but I much prefer to have the sentencing done in the courtroom. And so 95% of the sentences are done in the courtroom, or with the accused, though, sometimes on the link from the prison. So there's hybrid situations. Sometimes the accused in the court, sometimes the accused online from prison, sometimes the advocate in the court, sometimes the advocate online. And so there are mixtures sometimes of live hearing in the court combined with some remote online as well. Can I pick up, please, Frida, on just a couple of points from the questions? I hope I've dealt with a lot of them. But I liked a question or a point on the judge being part of a team. In other words, as the judge, you have to engage counsel. You have to treat counsel respectfully, give them time to develop arguments or make submissions to you when it's difficult. Perhaps the microphone isn't working, but you have to have patience. You have to work as a team with your own court staff, with the advocates, with the everybody else who comes into the courtroom. One point also, judges need to be IT literate. It's an obvious point, but you need to be able to control sometimes what's going on from your laptop. You need to be able to mute a person, or your court staff need to be able to do this. And you need to be flexible as well. This is important. I always make sure that the advocates have put their mobile telephone numbers come up on the screen and their emails come up on the screen. And so if a problem develops during the hearing, sometimes I just call them up or send them an email and we keep the hearing going. So you need to be flexible and responsive to what's going on in the courtroom.
Thank you so much. Before I go back to Domagoj, can I just pick up on a couple of those and just ask you some further points? So one issue that has arisen from analysis of other remote hearings is about this issue about being part of a team and how to balance the role of the judge as the sort of central authority and maintaining the order of the court, but at the same time having to rely, for example, on IT specialists or others in the court to facilitate those hearings. So have you perceived any challenges with maintaining that balance? That's the first question. And another issue that came up on the discussion forum and has been sort of underlying a lot of the debate that we've been having throughout the course is the suitability of various IT platforms to conduct these types of hearings. And I think Shota gave some really detailed good and best practice examples and mentioned that one of the platforms now had been changed and did not permit the judge to unmute, if that's correct, Shota, participants. So there are limitations imposed on what the judge can do through the platform itself. And I didn't know if you had any additional comments on those.
Thank you, Rachel. Point one about the balance with authority and maintaining authority as the judge in the courtroom. We've been doing this obviously since March 2020. I've not encountered any problems of any kind in terms of maintaining the authority of the court. If the advocates see that you are in control, that you are well prepared, that you are firm but fair, then my experience is they actively participate in the online hearings. And it's particularly important, as I say, that you're not too restrictive. So I've not had any negative experiences at all with maintaining authority within the courtroom. Second point, suitability of IT platforms. When the pandemic first hit, we took the decision in England to use Skype for Business. It was adequate for the first 6 weeks, 8 weeks. In that time, the government invested a lot of money in a bespoke program. It's called the Cloud Video Platform. It works extremely well generally, but it relies, as you will all appreciate, on the Wi-Fi connection strength of the advocates. And to go back to Domagoy's point, if you had an advocate in their office in Croatia, they will have a Wi-Fi speed there. But once you go into the countryside, so if we have advocates at home, the Wi-Fi signals in parts of the UK are not very good. And even I have Wi-Fi in my home in a more rural area of England, but I was issued with my own, dongle so that I had 5G connectivity from my home address. So we also, though, for other reasons, for judges' meetings, have been using Microsoft Teams mainly, but not generally Zoom.
Thank you so much. Domagoy, I'm going to pass over to you if you have any comments on the question raised in the chat function or anything that you picked up on the discussion forum or in response to anything Judge Raynor has said.
Thank you, Judge Raynor, for your answer. And I expected it that you just, interpreted the rules that are already existing. I'm sure that judges in Central Europe and Eastern Europe are firmly in control of their courtrooms, but honestly, I can say that sometimes we do have issues with discipline. And I think that online hearings are just broadening the scope and giving the whole new dimension to that problem or issue, so hopefully, there will be some rules or at least customs, so, best practices that will be accepted by the judges and the other participants. But for the good practices, you need some time. So probably the first steps will be a bit painful. Again, it's not connected maybe to online hearings, but it's connected to the pandemic. We do have especially strong pandemic among accused in my country, for instance. They are ill all the time. They're not going, they try to excuse themselves, and the judges are going crazy because they're even sending via their attorneys, they're sending thermometers, So the attorneys are approaching judges, said, this is the thermometer of my client from this morning, and it's 38.2, and we are not sure is it COVID or not, but I mean, better safe than sorry. So those kind of problems we are facing, and without proper statutes or good practices, it will be a problem. Again, I think that judges in Central and Eastern Europe and my country and neighboring countries are in control of their courtrooms, but obviously this new situation online is a new worry or new dimension to their daily practice of holding the whole proceedings in control. The same thing goes for the witnesses. Sometimes we do have unruly witnesses, So not to go further on that topic, I think that this is something that we also must take into account when we talk about online judging. Speaking of the type of the technology we are using, obviously it depends. In my country, the Department of Justice is in a position to purchase the technology for the courts. And it seems that the question of court discipline, whether the judge will be able to mute or unmute the participant, is, laying on the shoulders of somebody in the Department of Justice who is responsible for buying technology. Yeah, so I hope that I will send them this course to learn to take attention, to be attentive about it. Yeah, thank you.
I want to answer in this way. I think all the cases are pre-pandemic cases. And I think we have to recognize the enormity of the pandemic. In the UK yesterday, 1,500 people died. Our death total is now over 80,000 people. And if you look at our chart, the number of cases per day is doing this. It's not doing that, it's doing this. The extent of the pandemic has been recognized by our senior courts in other ways. I'm not going to go into the details, it's too boring, but they have said in court on multiple occasions, this pandemic is a wholly exceptional situation. I will give you one example. In England and Wales, we have a law which says that from the point when somebody is charged with a criminal offence, their trial ordinarily was to take place within 6 months of the date of them being charged. That would be extended in the big serious cases, but not in a routine case. That's 182 days. The law was changed in November 2020 to extend the 182 days to 238 days because of the pandemic and because of the exceptional situation. And so I think the authorities from the ECHR are of limited value. And my own experience is, and I know I'm not doing online trials, but my own expectation would be that even if you were doing an online trial, if it was managed properly, I believe that countries will be able to deliver fair trials compliant with Article 6 in online conditions. I think that's a very good question, and I suppose thinking generally, it's better to try and have consent to a procedure. But if the need to keep your criminal justice systems going is so severe, then it would be better, wouldn't it, to have a law, a new law saying this is what we're doing, rather than relying on the consent of parties to agree to a procedure. Just one quick point on that. The new law in England and Wales had been passed through Parliament by the 25th of March of 2020. So we had a new act, a new piece of law. It was called the Coronavirus Act of 2020. And all judges had a written pack of guidance on that law by the 26th of March 2020. And so it obviously makes your job easier if you have a detailed law quickly. In that case, I was at home connecting online to my courtroom. In my courtroom, I had my court staff. In every courtroom in England, we have an audio recording facility. And so there was the usual audio recording of what I was saying, but I did speak slower. I made sure that both the defendant and the accused and his advocate could hear me, understand me. And I took the precaution in that case also, Ilya, of producing written sentencing remarks. They ran to 24 pages, and I circulated that document to the advocates at the start of the hearing. But sometimes I don't have time in an English criminal court to write up sentencing remarks. I would be working 29 hours a day. But in the very serious cases, I do produce written sentencing remarks and I read them out verbatim. But on all cases, there is always an audio recording kept of what is happening in the courtroom.
Thank you for that. And Domagoj.
I just wanted quickly to go back on the question of consent. That is exactly the position of the Central European authorities, at least the authorities in my country, that you need a written law, new piece of law, which will regulate the online hearings and trials to avoid, the double standards, that type of problems. And we are eagerly waiting, because I'm really looking, as a judge, I'm really looking forward to it. For many years, I'm seeing people entering and going out from my courtroom, so I'm perfectly fine with doing it over computer. So I think during this year, 21, in my country, Croatia, we are expecting the amendments to the civil procedural law, which will have the provisions about the online trials for the civil courts. So that's the point of view of the authorities, the parliament and the government in Croatia, that you do need the written law, not just interpretation of the and consent of the participants in trial. That's what I wanted to add. Thank you.
Thanks so much. So at this stage, actually, Rachel, I'm going to hand things back over to you again.
So I just want to conclude to say a huge thanks to our speakers for their really insightful comments, and to all of you for the fascinating questions. Thank you.